This training presentation is going to focus on private property rights. In particular, I will focus on the historic background and legal context of the private property issues that tend to come up when making public planning decisions. As you are likely well aware, there's often a conflict between private property rights and the public interest. As planning commissioners and BZA members, it is important to know the legal limitations of planning so that you can strike that hard-to-find balance between private property and public interests. These are the topics I will cover in this presentation. Given that many of the protections for private property stem from the Constitution and case law, we're going to be looking at several court cases and their impact on planning. Of course, case law can be complex, and I'm not an attorney. And I will be the first to admit I don't understand all of the legal forces and constructs involved. Examining these cases, I think, though, will be an informative way to see how we've gotten to where we are in terms of private property rights. But of course, the advice of an attorney is recommended whenever confronting these issues when making planning decisions. First, let's take a look at a few things from the Constitution. Due process is a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. It is a constitutional protection designed to ensure fairness in the implementation of laws and regulations. Due process stems from the 5th and the 14th Amendments in the U.S. Constitution. The 5th Amendment guarantees due process with the federal government. The 14th Amendment is protection from the states. How does due process affect planning? A couple of things. One, it requires that we provide notices of meetings and run ads in the paper, at least until the state legislature decides to allow us to run these ads in a different manner. So far, all those amendments have not passed. Due process calls for commissions and BZA boards to have public hearings, which give an opportunity for property owners to make their case. It's also one of the reasons for the Tennessee Open Meetings Act, or the Sunshine Law. Planning commissions take meeting minutes, the purpose of which is to create an accurate record of official decisions and to show that commissioners have considered all relevant factors when making these decisions. Failure to follow due process can invalidate critical decisions that affect entire communities. Although many requirements seem redundant and unnecessary, following all the right steps is essential for protecting local governments and individuals' property rights. The legal notice requirements for planning commission hearings is very basic. Some specific actions require 15 or 30-day notice in the paper, amending the subdivision regulations or a Board of Zoning Appeals hearing, for instance. Other actions simply require adequate notice, which is not defined by the law. Providing more notice than required by state law is considered a best practice. Examples could include letters to impacted property owners, signs on the property, postings on website and social media. Some of our communities have adopted these best practices into their zoning ordinance and are now a requirement for those communities. An important thing to keep in mind is that lack of public input does not always mean public approval. It could simply mean that the public notification has not been very effective in reaching members of the public. For changes to meetings or special called meetings, the law only requires that adequate notice of meetings be published. What is adequate and what methods are effective advertising is not clearly defined by the law, but has been ruled on, at least to some degree, in court. In the case of Englewood Citizens for Alternative B versus the Town of Englewood, the court ruled that notice for special called meetings required, and I quote, "First, the notice must be posted in a location where a member of the community could become aware of such notice. Second, the contents of the notice must reasonably describe the purpose of the meeting or the action proposed to be taken. And third, the notice must be posted in a time sufficiently in advance of the actual meeting in order to give citizens both an opportunity to become aware and to attend the meeting." In the Englewood case, while the court felt the location of the public notice was adequate, the court found that the notice did not adequately identify what was to be decided on at the meeting. In this case, it was a proposed alternate route to the State Route 411. A specific time frame is not given for special call meeting notices. The courts would take into account consideration of the manner in which the notice is published. Being posted at Town Hall, for instance, would require a longer notice period than a newspaper publication. Equal protection. This is a constitutional protection against the unequal application of laws to different groups and parties. The key takeaway from equal protection is to remember that citizens and property owners have the right to unbiased, fair, and equal treatment in zoning and other administrative decisions. Now, there is one federal and 2 state land use laws related to equal protection that we are going to take a look at. The federal law we are going to discuss is the Religious Land Use Institutionalized Persons Act, which protects religious organizations from burdensome land use policies. The law prohibits communities from treating religious organizations differently from non-religious organizations and from discriminating based on which religion or denomination the organization is affiliated with. The RLUIPA was enforced through a recent case regarding tiny homes in Tennessee. In 2017, Metro Nashville cited the Religious Land Use Institutionalized Person Act as a reason to approve a tiny home village proposed by Glencliff United Methodist Church in 2017, despite tiny homes not being a permitted use in that particular zone. The neighbors sued the government, but in 2019, the Court of Appeals upheld the original decision to allow the tiny home village as an extension of the church's religious practice. Today, the village at Glen Hill provides housing to medically fragile individuals experiencing homelessness. When it comes to land use decisions related to houses of worship, I would recommend consulting with an attorney to ensure the RLUIPA is being upheld properly. At the state level, there is an equal protection law involving manufactured homes. In many of our communities, we get a lot of questions about mobile homes and the differences in where they can be placed. State law protects manufactured dwellings, including double-wide mobile homes, and says that they must be allowed in any residential zoning district. However, the second bullet point, this protection does not extend to single-wide mobile homes. Courts recognize single-wide as a form of affordable housing which cannot be prohibited outright by a community except in extremely rare cases, but they can be reasonably restricted to certain zoning districts and trailer parks. The final equal protection item we're going to look at involves group homes for persons with disabilities, including mental illness. These are protected from discriminatory zoning practices by state law. As you can see, the definition of single-family residence in this section of Tennessee Code allows up to 8 patients and 3 support staff. In other words, wherever single-family residents are allowed, these group homes are also allowed. A lot of residents have concerns about these group homes going into their neighborhoods. You should hear them out, but at the same time, try to educate them about this section of the state law that must be followed. Private sector in mental health treatments industry seems to be growing, so this issue may come up more frequently in our communities. One other quick note on this topic, the U.S. Supreme Court has ruled that requiring a special permit for businesses that deal with persons with a mental illness but not requiring that same permit for non-disabled people in a similar venue is a violation of the Equal Protection Clause, City of Claiborne versus Claiborne Living Center in 1985. I'm not aware of any such practices in our region, but it could be challenged at some point if that happens to be on the books in your community. Next up, takings. Takings, which includes eminent domain, stem from the Fifth Amendment, which states, "Nor shall private property be taken for public use without just compensation." So what does this mean for planning? Eminent domain is probably a concept you're familiar with related to takings. We're actually going to talk about eminent domain in more detail later in the presentation. For now, we're going to look at the concept of a taking. This is perhaps the crux of private property rights debate. Takings have a long legal history and continue to be fought out in the courts across our country. For our purposes in this training, a taking is the loss of economic value of private property due to an action or regulation by the government. If there is a taking, the Fifth Amendment of the Constitution requires that just compensation be paid. This is typically determined based on the fair market value of the property in question. Regulatory takings may result from a variety of government actions, from conditions for permit approval to enactment of especially burdensome land use restrictions or environmental regulations. Now, mere loss of economic value due to government action does not necessarily mean a taking has occurred. Land uses may be restricted under the government's police powers, which we often see in zoning. Land restrictions in zoning statutes will likely not be considered a taking unless they deprive an owner of all use of his or her private land. Perhaps the easiest way to understand this is that land uses may be restricted, but to deny all land use would probably amount to a taking. Even then, the facts of a particular case could throw this rule out the window, which is why we've included an asterisk here on this slide, saying that sometimes this is how the rules apply. Is zoning a taking? Zoning obviously prevents you from opening, say, a car wash in the middle of a neighborhood. This restriction means you would miss out on a lot of revenue, but it also means your neighbors get to appreciate less noise and traffic that would be caused by the business. As I mentioned, the courts have long held that restricting land use does not necessarily amount to a taking. There are still other uses for this property, like building a house, which would be in line with the zoning regulations for that district. All property owners within the zoning district must adhere to the same standards, that is, assuming you're administering your ordinances equally, which goes back to the Equal Protection Clause, which we talked about earlier. Now, as I'm sure many of you are aware, zoning changes result in existing land uses becoming non-complying with the zoning ordinance. We call these non-conforming uses. These are allowed to continue so long as they remain in operation. We will look at protections in Tennessee state law for non-conforming uses later in this presentation. But first, we're going to look at a few cases where the Supreme Court weighed in on the issue of takings. This first case is an example where laws passed by the state of South Carolina resulted in the full loss of economic value of an owner's property. In 1986, David Lucas purchased two beachfront residential lots on the Isle of Palms near Charleston. The arrows here show his two lots on either side of his existing house. The laws at the time he purchased the properties would allow him to construct one house on each parcel. 2 years after Lucas bought his lots, the state increased regulations on coastal land. The new laws deprived Lucas of the ability to erect homes on his property, right next to where other homes already stood. The case went all the way to the U.S. Supreme Court, which found that the state's new law deprived Lucas of all economically beneficial use of his land. The court said that Lucas had certain investment-backed expectations, which meant that he had purchased the lots with full legal rights to build homes. That is, until the state of South Carolina changed its laws. Under the new regulations, Lucas could do nothing with his property, even though in the dissent, one justice actually suggested that he could still use the property for tent camping. The loss of value amounted to a clear regulatory taking, and the state was ordered to compensate Lucas for both lots. Next is Nolan versus California Coast Commission, or CCC. The plaintiff in this case applied for a permit to replace a small home on Ventura Beach with a new 2,500 square foot house. Approval of the permit required that a public beach access easement be established along their property, and the Nolans filed suit claiming this was a taking of their property without just compensation. The defendant asserted that the easement was to promote legitimate state interests of diminishing the blockage of the view of the ocean, which was caused by the construction of a larger house, replacing the smaller house. Here on this slide, it shows the strip of beach behind the Nolans residence where the California Coastal Commission was requiring a 20-foot wide lateral easement going along the beach. You can see the Nolans house here. 43 other owners had consented and allowed public access, improving the easements on their property. The Nolans were the first one to fight this easement provision. In their ruling, the U.S. Supreme Court said that the government regulation must have an essential nexus to the stated public policy goal. That is, there must be some logical correlation between the supposed problem and the remedy. The California Coastal Commission claimed that because the larger house would block the public view of the ocean, property owners should be required to open their private property to public beachfront access through this easement requirement. The Supreme Court didn't buy it. Requiring the Nolans to give up their private beach was an inappropriate policy to mitigate for blockage of the view of the ocean. The court did not see the connection between the policy and the stated goal. The court's opinion was blasted the alleged psychological impact to the public from the blocked ocean view. The building restriction is not a valid regulation of land use, but an out-and-out plan of extortion was stated in the Supreme Court ruling. Justice Scalia wrote, "If they are serious, a more appropriate requirement for the CCC would have been a public viewing platform on top of the Nolan's roof." All right, let's move away from the ocean and take a look at a takings case inland. This case is from Portland, Oregon, and addresses more modern planning concepts and requirements that some communities in our region have considered or included in the regulations. In this case, the developer applied for a permit to expand a store and pave a parking lot. The city code required a 15% open space and landscaping to be reserved, easement for a bike and pedestrian path, and the dedication of land in the 100-year floodplain for storm drainage improvements. It was unclear whether the dedicated property and easement was to be deeded to the city. If that was the case, it makes everything much more understandable. The applicant requested a variance to these requirements and was denied. It was appealed all the way to the Oregon Supreme Court and ultimately the U.S. Supreme Court. The developer claimed that the city's dedication requirements were not related to the proposed development. Rather, it was related to the stormwater drainage and greenway plans of the city, not the stormwater drainage specific to the proposed development, meaning that the required dedication amounted to a violation of the takings clause of the Fifth Amendment. This photo here shows the multi-use path that was required to be dedicated to the city. The court held that while the required dedication met the essential nexus test of the Dolan case, the requirement exceeded the impact of Dolan's proposed development. In other words, the city was requiring that too much property be dedicated. The court ruled that the city failed to make an individualized determination and that the required dedications must be related in both nature and extent to the proposed impact of the development. The two-pronged test for requiring public dedication of real property that stems from these cases is referred to as the Nolan-Dolan test. And if this sounds familiar, it is because in 2022, the Tennessee legislature codified the Nolan/Dolan test. In the approval of plats, planning commissions can now only require the dedication of real property when there is an essential nexus between the dedication and a legitimate local government interest. In practical terms, we have recommended that our planning commissions update the language in their subdivision regulations regarding the dedication of right-of-way along existing roads. Previously, many planning commissions would require anyone that is subdividing along existing roads, which are often narrower than today's standards, to dedicate property to meet the current right-of-way standards. This requirement is no longer allowed unless it meets the Nolan/Dolan test. And an instance where it might be allowed would be if the right-of-way was not wide enough for a school bus or fire truck access. And even then, the Planning Commission could only require the width necessary for fire trucks or school buses, which may or may not meet the new standard for road widths. Okay, let's take a look at floodplain regulations in light of this takings doctrine. The NFIP, or National Flood Insurance Program, offers flood insurance to property owners in communities that are enrolled in the program. Each community, in turn, must adopt regulations for development in flood zones. These restrictions on land use and private property have resulted in a proliferation of takings claims. Those of you familiar with floodplain programs know that compliance can be extremely costly and sometimes cost prohibitive on individual property owners. In some cases, building to the NFIP standards is simply not feasible, and this affects the economic potential and marketability of the property. Some of the basic provisions and restrictions in developing in floodplains include requiring elevation certificates, not allowing them to develop in floodways without a no-rise study, which is extremely costly, and things like raising up buildings above the base flood elevation. Most floodplain ordinances either prohibit or place tight restrictions on development in floodways, and most subdivision regulations require that each lot have a flood-free building site. This flood map shows Roaring Creek in the city of Graysville, and here's the floodway. All of our ordinances require floodproofing or elevating above the base flood elevation. The state of Tennessee mandates at least 1 foot above the base flood elevation. And you can see in this picture where the house has been elevated, although there is something wrong, and you can see the bottom of the vents, flood vents here, are supposed to only be 1 foot above the ground, no more than 1 foot above the ground. So let's take a look at some court cases related to flood development standards. Courts across the country, including the U.S. Supreme Court, have shielded the floodplain program from repeated legal challenges and taking charges. There are a lot of cases, but we're going to look at 2. In Texas Landowners v. Harris, the United States Supreme Court upheld a finding that decreases in property values due to floodplain restrictions do not constitute a taking. Moreover, if a community chooses not to enroll in the NFIP, any federal sanctions that result in decreased property values, such as non-eligibility for flood insurance and certain grants, would not constitute a taking. The responsible citizens in this Asheville case claim that the floodplain regulations for Asheville, North Carolina, which are pretty similar to the regulations in our region, were unconstitutional. The entire ordinance was attacked, including the requirements to elevate buildings, floodway restrictions, and other measures. The North Carolina Supreme Court found that Asheville's floodplain development standards were in fact constitutional and reasonably necessary to further the stated public goal of preventing or reducing flood damage. The, quote, reasonableness of the construction standards and land use restrictions the court held did not amount to an unconstitutional taking. In response to the Asheville case, FEMA's Office of General Counsel issued legal opinions that for an unconstitutional taking to occur, floodplain regulations must deny all reasonable use of an entire property. FEMA regulations are not absolute prohibitions. Rather, they are allow development provided that certain standards are met. It is technically feasible to meet these standards in most cases with the proper engineering and design. I am unaware of any NFIP takings cases in Tennessee, although there are some communities whose floodplain ordinances prohibit any subdividing or development in flood zones. Some even require flood areas to be dedicated as open space. Although these haven't been challenged in court yet that I know of, it could possibly be challenged and could potentially amount to a taking. I just wanted to touch on floodplain variances quickly since we're talking about the NFIP. It relates to private property rights in several ways. People want to build homes and businesses in our communities. If they are developing in a floodplain, they have to adhere to floodplain regulations. However, many lack the resources to fully comply with the regulations, especially in today's economy when prices are always increasing. I'm sure you've heard requests for NFIP variances due to cost and hardship. You may have also heard that owner's property has never flooded and they've lived there for 40 years. But we have to go by the FEMA maps. If you think they're wrong, there is a map revision process that you have to follow. It's expensive and it takes a long time. But at the training sessions that we attend, the FEMA representatives tell us over and over again, do not grant variances. Variances undermine the intent of the floodplain regulations. They pass the safety hazard on to subsequent and neighboring property owners. You should really follow the ordinances as they're written and work with your floodplain administrator to ensure that your community remains in compliance. If FEMA suspends a community from the NFIP, there are very significant consequences for the entire community. Things like no new insurance policies being issued, loss of eligibility for federal grant, and ineligible for federal disaster assistance in the case of floods. For the next topic, eminent domain, we're actually going to look at just one court case, the impacts of it and the impacts that it had on private property rights. Eminent domain is the process of the government forcibly taking real property for specific government purposes that benefit the public. As with all takings, this requires just compensation for the property owner. If you follow politics, chances are you've heard of Kelo versus New London, Connecticut. It was a Supreme Court case from 2005 dealing with the government's powers of eminent domain. Suzette Kelo lived in a little pink house overlooking the Long Island Sound in Connecticut. This was a historic neighborhood where many of the families had lived for nearly 100 years. The homes were in good repair and not blighted or anything. However, the day before Thanksgiving in the year 2000, the residents here received notices of condemnation from New London Development Corporation. This was a private entity to which the city had conferred eminent domain authority. The corporation wanted to build a hotel, office space, condos, and other features to contribute to the city's economic development. The only problem was that the land for this large-scale development plan was located under Miss Kelo's house. The residents challenged the use of eminent domain by the corporation, and the case went all the way to the Supreme Court. The court had to consider whether economic development was an appropriate use for eminent domain. In addition, can the government legally seize property from one private property owner and give it to another? If we look at the Fifth Amendment, the government may take property for public use. Now, eminent domain is frequently used for road projects, parks, and schools, things like that. The City of New London, in this case, said that economic benefits from redeveloping Kelo's property constituted an appropriate public benefit. Note that this is different from what the Constitution says. Economic development, the city argued, should be an acceptable justification for economic domain because the benefits it generates for the public. And the Supreme Court agreed. They said that because Kelo's property was part of a larger economic development scheme for the area, one which was done, quote, comprehensive and carefully considered, and because taxes, jobs, and economic development benefit the public, the eminent domain procedures could move forward. After losing the case, Kelo and the other residents who lived there their entire lives were forced to move. Miss Kelo was fortunate and was able to raise money to have her house relocated. In total, the City of New London spent over $78 million to compensate property owners to clear the site for new development. The sad part is that the redevelopment project has ended up being a complete failure. With the recession, most of the private sector commitments for this project folded or backed out. As you can see looking at these pictures, the businesses and homes have been replaced with a lot of vacant real estate. This is what it looks like today. As with many recent Supreme Court decisions, this one created an absolute uproar. Why? Well, the decision basically meant that governments could use eminent domain to take your private property and give it to another owner or private developer. All they had to say was it would generate increased tax revenues. Private property rights advocates and people from every walk of political life were outraged. In the wake of the Kelo decision, President Bush issued an executive order preventing the federal government from using eminent domain to advance private economic interests. As of 2009, 43 states had amended their eminent domain laws to prevent what happened in New London. Tennessee's state law, as you can see here, was amended in 2006 to forbid using eminent domain to confer a private use or benefit. In addition, economic development, including increased taxes and job creation, cannot be used as justification to take private property through eminent domain. So we've covered equal protection, due process, takings, and eminent domain. That wraps up everything we're going to talk about dealing with constitutional property law. Next, we're going to talk about nuisance. A nuisance is an annoyance or source of injury to the public or surrounding property owners. Common nuisance cases involve odors, noise, vibrations, and other hazards. Sometimes the courts have sided with the people complaining about the nuisance. Other times they have sided with the person or company generating the nuisance. In terms of relief in these types of cases, courts will sometimes compensate the injured party for damages, or depending on the severity of the nuisance, they may also issue a temporary or permanent injunction, which means shutting the business or operation down until the problem has been solved. Early nuisance cases coincided with the growth of America's cities. Problems arose as people moved into or near heavy industrial areas, and also as suburbs extended into agricultural areas. Nuisance is divided into public and private spheres. The distinction is important, but not something we will delve into all that much tonight. In a nutshell, private nuisance cases involve just one person or a small number of property owners. They arise when an activity or land use on one owner's lot interferes with the use and enjoyment of another's private land. A physical invasion isn't necessary. It's usually the byproducts or consequences of an activity causing the disturbance. Public nuisances, on the other hand, involve a considerable number of people, sometimes a whole neighborhood or community. They may involve something that is offensive to the senses, indecent, or interferes with so-called public rights such as free passage and access. The courts recognize two categories of nuisances: nuisance per se and nuisance in fact. The first is an activity or land use that is offensive simply due to the nature of the operation. Usually per se nuisances have been declared as such and are prohibited by law. In Tennessee, this includes some of the examples you see here on screen. I think we can all agree that yes, illegal drug operations like meth labs are a nuisance. Then we have nuisance in fact, or per accidens. Unlike the previous category, these are oftentimes completely legal operations and land uses, but due to the circumstances, they generate enough of a problem or for nearby property owners that they become classified as a nuisance. Location has a lot to do with this nuisance category. Problems arise when two incompatible land uses butt heads. Most of the ones I'm familiar with involve industrial or agricultural operations and their effects on nearby residential districts. Just flipping through a few pages in a law book in our office, I found dozens of nuisance cases. Here are a few examples that courts have declared as nuisances in residential districts. Most of these make sense. Like feed grinding and mixing, noise from windmills, telecommunication towers, a tuberculosis sanitarium. These make sense. For funeral homes, the book noted that the buildings are often very nice and well kept, and the traffic they generate is sporadic. However, funeral homes invade the integrity of residential neighborhoods and disturb the seclusion to which residents of these neighborhoods are entitled. Reminders of death and the coming and going of caskets and mourners are depressing. Most courts will declare funeral homes in residential neighborhoods to be a nuisance for these reasons and order them to close or relocate. Another quick note, courts evaluate these on a case-by-case basis. Junkyards and livestock, as you can see, sometimes are and sometimes aren't nuisances. It all depends on the facts of the particular situation. The number of nuisance cases has decreased with the rise of zoning. Today, separating land uses through zoning will prevent, for example, a brick factory from opening in a quiet neighborhood. Similarly, new residential construction should not occur in industrial districts. However, a zoning ordinance that authorizes a use that someone claims to be a nuisance can cause problems. This is because zoning is a legislative declaration that a use is compatible with the surrounding area. In other words, your local government is saying it's legal for that land use to go there. This is something to keep in mind with spot zoning. When a commission approves a zoning change, they need to be aware that anything allowed in that zoning district, not just what is being proposed by the specific applicant, could potentially end up on that property. The good news is that even with zoning, most courts aren't afraid to step in and shut down a nuisance land use. Now, if a community does not have zoning, understand that there is very little legislative mechanisms available to prevent incompatible land uses from going side by side. In those situations, the only recourse may be to file a nuisance claim. However, as we're about to see, there's no guarantee of a favorable outcome. Some courts will side with the party affected by the nuisance. Other times it will side with the party causing the nuisance. In this case, Antonia Bove built a grocery store with several upstairs apartments in the industrial area of Buffalo, New York. There were railroads, warehouses, and industrial plants already here. Smoke and dust from these drifted onto the property, getting inside the apartments and causing respiratory problems for the occupants. Bove filed a private nuisance suit, which kind of backfired on her. The court told her it was obvious she had chosen her location to take advantage of the cheap property. She knew full well that this was an industrial area. There is no reason the plant should have to close because of her or be required to pay her damages. Basically, they told her to suck it up or move. A lot of times the outcome depends on the economics involved. When courts do this, it's called balancing the equities. Here, landowners next to a cement plant sued, alleging the dirt, smoke, and vibration from it constituted a nuisance. Now, the plant represented a $45 million investment and employed 350 people. The damages to the plaintiff's property, on the other hand, were calculated at $185,000. The first few courts refused to close the plant. The economic benefit outweighed the problems it caused. The landowners kept appealing until an appeals court agreed to close the plant, at least temporarily. Once it paid damages to the landowners, it could reopen. As you can imagine, they paid them off pretty quickly. The case is interesting because it recognized that the plant was a nuisance for the surrounding property owners, but after paying out damages, the nuisance would basically receive legal status, being allowed to stay open and continue polluting. What happens when a completely legal business finds itself in a nuisance lawsuit because someone else came in and decided to build a house next door? This is what happened in the Bove case a few slides ago. Courts call it coming to the nuisance. As you recall, in the Bove case, the courts refused to shut down the polluting factories around her property. After all, it was she who decided to put apartments in an industrial part of town. Typically, courts will recognize when plaintiffs have created their own mess and refuse them any relief. In the Arizona case you see here, developer Del Webb built a large retirement community downwind of a feedlot for 30,000 head of cattle. The testimony indicated that at 35 to 40 pounds of wet manure per cow per day, there was over 1 million pounds of poop every day. Del Webb claimed that the smell and the flies prevented them from selling upwards of 1,300 lots on their development. Now, Arizona's state law says that breeding places for flies fall under the public nuisance category. Accordingly, there was very little wiggle room due to this law, and the feedlot was ordered to relocate or shut down. The court, however, placed the blame fully on the lap of the developer, stating that they had come to the nuisance. Del Webb was ordered to pay the full relocation costs and other damages to Spur. In this case, the court said that if you put yourself in the way of a legal business and are nuisanced by it, you may get an injunction to make the business move, but you will most likely have to pay the cost incurred by the business. In Tennessee, we have the Right to Farm Act, which protects agricultural land uses from nuisance claims like the one we just saw. Just about anything farming related that was already in existence when a new use moves in has legal protections against nuisance cases in this state. Now for a few famous nuisance cases from right here in our backyard. I don't mean to pick on Ducktown, but in the early 1900s, the city's mining companies generated a series of nuisance cases that were monumental for American legal and environmental history. We have to talk about them. In Madison versus Ducktown Sulphur, a private landowners sued the copper companies in Ducktown because the emissions released during the smelting process were smelly and were killing all the vegetation in the region. The case ultimately made it to the state Supreme Court, which instead of issuing an injunction, decided that the value of the industry far outweighed that of the individual's landowner's property. Closing the plant would cost millions and put lots of people out of work. In addition, one justice noted that if not Ducktown, where? He actually said this, that there wasn't any place more remote than Ducktown that the plant could move to. In the end, the court did award monetary damages to the plaintiffs, but left the smelters open. Then, in 1907, the state of Georgia filed a public nuisance case against the Tennessee Copper Company in Ducktown. Georgia claimed that the emissions were coming across the state line, destroying its farmlands and poisoning its residents. The Supreme Court sided in Georgia's favor. They issued an injunction and the copper plant had to close. Here, the property owners won, sort of. After some follow-up modifications to their plant and negotiations with Georgia, Tennessee Copper was able to reopen. However, several other plants in Ducktown were forced to close. Counties have the option to regulate nuisance and land uses without zoning through the County Powers Act. This can be particularly useful in smaller, more rural counties where the enforcement of zoning is impractical. Utilizing the County Powers Act requires a 2/3 majority vote of the County Commission. Because this doesn't involve Planning Commission action, I'm not going to go into detail what the County Powers Act enables the county to regulate, but I want to make sure you're aware of this additional land use regulation tool. I will also mention that a potential landmark case from Grundy County in our region is currently in front of the Tennessee Court of Appeals. It is related to whether the County Powers Act can be used to limit the location of certain industries already regulated by the Clean Water and Clean Air Acts. In this case, they're talking about a sand quarry. The county's position was upheld at a lower court, but we will have to check the news to see how the appeals court rules. To wrap up, we're going to look at non-conforming buildings and land uses. Each community's regulations treats these slightly differently, so it might be worth it to review your policies with your planner. State law also has something to say about these, so let's take a quick look. What is a non-conforming use? The City of Whitwell's zoning ordinance defines it as follows: a building, structure, or use of land existing at the time of the enactment of this ordinance, which does not conform to the regulations of the district in which it is situated. As Red Bank's zoning ordinance notes, the passage or amendment of the zoning ordinance or map does not affect existing lawful businesses. However, if the building is removed or if the use is discontinued for 100 days, or the limit as established by your community, new buildings and uses must conform to the current zoning regulations. Although, as we'll see on the next slide, or in a few slides, there are certain protections for businesses in Tennessee. There are two types of nonconformities: buildings and land uses. A non-conforming building may be one that encroaches into the setbacks or was too tall for the zoning district as it's designed now. A non-conforming land use would be, for example, a mechanic shop in an area that is now zoned residential. State law broadly protects industrial, commercial, and business land uses. Most of the region's ordinances, therefore, has a section specifically for those uses. We'll take a look at those in a minute. For other land uses that do not fit into the commercial category, most ordinances have fairly similar provisions. In Etowah, once a non-conforming land use has ceased operation for 6 months, it loses its protected status. The new use must conform with the current zoning. Any change to a non-conforming mobile home triggers the current zoning regulations, which means that in Etowah, a new single-wide mobile home would not be allowed back onto the property unless they're allowed as a use within that district. Communities usually include provisions for structures damaged by fire, flood, wind, or other acts of God or man. Graysville is fairly generous in that owners have 1 year to get a new building permit and another year to reconstruct the building. Others allow the building to be repaired but not fully replaced unless the new structure conforms to the zoning ordinance. As I mentioned, Tennessee state law includes additional protections for non-conforming industrial, commercial, and business land uses that are zoned by a municipality. These businesses are allowed to expand operations and construct additional facilities as long as they are continuing with the business activities that were taking place on the site prior to the change in zoning or zoning regulations. If a use ceases to operate for 30 or more months, they lose this protected status and must conform to local zoning regulations. No building permit shall be denied to industries or businesses seeking to expand, provided there is a reasonable amount of space for such expansion on the property. Businesses that are non-conforming uses may also destroy their present facilities and reconstruct them as long as the land use will not change from the previous operation. This only applies to city zoning. This section is not repeated in county zoning regulations in Tennessee Code. There are also Tennessee Code provisions for non-conforming multifamily residences, such as apartments. These are allowed to be rebuilt if there is damage from a fire or natural disaster. However, they cannot be constructed beyond their original dimensions and must adhere to any applicable architectural design standards in effect under the current zoning ordinance. The Vested Properties Rights Act was passed in 2014. This act locks in the current zoning and subdivision regulation standards for a developer once they receive approval. The vesting periods are different depending on the type of approval, and they can be extended if construction commences and permits are maintained. Preliminary plats are vested for 3 years, and approval of the final plat allows for an additional 2 years to commence construction. A total vesting period of 10 years is allowed if construction begins within the first 5 years. Multi-phase development projects have separate vesting periods for each phase and may have a total vesting period for all phases of 15 years. So now we have a few scenarios that I'll read through and then give you my take on them. For scenario 1, an applicant submits a preliminary plat for a residential subdivision which meets all of the requirements in the subdivision regulations and zoning ordinance, as well as complies with the land use plan. The neighbors oppose the development because they want the land to remain open space. In this common scenario, I would recommend approval of the preliminary plat. There would need to be a very good reason to turn down a plat that is in compliance with current regulations, including subdivision regulations, zoning ordinance, and land use plan. Now, if the Planning Commission sees that there's something they don't like about the development, that would be a time to reassess your regulations, make some changes so that they can be applied to the next development. At this time, once the plat is submitted, you need to approve it if it meets your regulations. For scenario 2, the applicant submits a site plan For approval of a commercial building, the Planning Commission would like sidewalks to be built along the road, but there are no requirements to do so. The Planning Commission approves the site plan contingent on the developer constructing sidewalks. In this scenario, I would recommend against this course of action. The community could consider negotiating the purchase of property for sidewalks, but requiring sidewalks for approval could be considered a taking and may not meet the Nillen-Dolan test that is required by state law. The city may also consider requiring sidewalks along any future roads through the subdivision process by adding this requirement to their regulations. In scenario 3, the applicant submits a preliminary plan for a subdivision next to an existing park. The city would like additional land for the park and requires that the developer give 2 acres of land to the city in order for the preliminary plat to be approved. Much like the first scenario, if the preliminary plat meets all the requirements, it should be approved. The subdivision regulations or zoning ordinance could have an open space requirement, but communities can not require that space be dedicated for public use in this manner. The scenario would not meet the Nillen-Dolan test that I presented earlier. The city could consider negotiating with the property owner should they like to purchase the land in order to dedicate it to park space. Scenario 4. The applicant would like a rezoning for a property in a residential area, changing it to commercial. The Planning Commission has denied such rezonings in the past based on incompatibility with the area. The applicant assures the PC that the use won't disrupt the neighborhood. The PC recommends approval of the rezoning. In this scenario, I would recommend against approval. While the specific proposed use may not disrupt the neighborhood, a change in zoning will likely allow many other permitted uses, and future owners might implement one of those uses, which may be considered a nuisance within the residential neighborhood. Additionally, you would end up with spot zoning concerns by rezoning a specific piece of property for the benefit of that property owner and to the detriment of the rest of the neighborhood. In scenario 5, the Planning Commission receives a controversial rezoning request. The PC members decide to meet for a dinner a week before the meeting and discuss how they'll vote. In this case, the Planning Commission is in clear violation of the Tennessee Open Meeting Act, also known as the Sunshine Law. These decisions must be deliberated at public meetings and not privately among members of the Planning Commission. And now, to wrap this up, some key takeaways from this training. First, we all probably know land use regulations are a key component for promoting the public interest, but these decisions must be made in respect to the law and to private property rights. Decisions need to be based on established plans, regulations, and legal precedent, not on regulations that you wish you had in place before you received an application, which means you might have to approve something you don't like due to a gap in your regulations. And you just have to accept that and then change the regulations for the future. And the last point is to be fair and consistent. Who the applicant is irrelevant. It's the nature of the request that you need to be considering and basing your decision on.